should include required addendums to leases. So there's a certain number of required addendums that you're required to have with your lease, okay? Here's some of them, and the AOA has all these. The mold addendum, the bed bug addendum, the EPA lead booklet, Megan's Law, rent control disclosure. The rent control disclosure is fairly new. Basically, if you own, let's say a single family residence and it's owned in your name, or let's say the name of the trust, and it's not a corporation, or an LLC that has a corporate lead member, then you're exempt from the rent control laws if you give this exemption notice. If you don't give this exemption notice, or if it's not in your lease, you're not going to be exempt from the rent control laws. So if you have units out there and you haven't done it yet and they're not part of your leases, we recommend contact my office or some other office to get that notice out to your tenants, so at least you have it out there. So the rent control disclosure, you have to disclose it, or else you're going to still be subject to rent control, even though you could be exempt. Lead disclosure addendums, flood disclosure, periodic pest control disclosures, and the city of San Diego only, this is fairly new, recycling disclosures and addendum. So you can thank your state and city legislatures for basically making this simple rental agreement a couple years ago to something that's become a beast, unfortunately. But I think you can get this all together in a lease. Like I said, AOA has a great lease you can use and have all these disclosures. Another thing, sometimes I see rental agreements that are like 100 pages long. I'm just talking about just the lease portion, not the addendums. Sometimes longer is not better. I prefer to have a nice, shorter, concise lease. I think the AOA lease is probably, not including the addendums, maybe 2 pages long, 3 pages, 4. Recently, they pushed it up to 4. I don't need to see a 30-page rental agreement with your tenants. That's okay in commercial settings, but sometimes the longer, it just starts becoming inconsistent. The provisions start to conflict, and it makes it almost impossible for a tenant or anyone else to review that lease and figure out what the heck it says. So longer is not always better. Let's move on. So things you should look for in your lease agreements. The first and most important one, this is the second thing you're going to take out of this agreement, is your attorney's fees clause. You do not want to have an attorney's fees clause in your lease agreement. What is the attorney's fees clause? The attorney's fees clause says the prevailing party, if there's a legal action that's instituted, the prevailing party is entitled to their attorney's fees and costs. Well, you might ask, what's wrong with that? Here's what's wrong with that. I'm trying to kick out somebody. You have an uncapped attorney's fees, meaning it's unlimited what the attorney's fees can be. The only restriction is they have to be reasonable, okay? I'm never going to tell a client, I guarantee you're going to win at trial. A lot of things happen, okay? So what happens? Let's say you win a judgment against your tenant for $1 million. What are the chances are that you're going to collect $1 million from your client, from your tenant? Probably 0, because they can always go out and just file bankruptcy. But let's say the reverse is true. Let's say there was a mistake. Hey, we serve a 3-day notice to pay rent or quit, and your manager accidentally took money in the middle of the eviction, and we didn't know about it until the trial. Well, you accepted money after the 3-day notice expired, you lose the case. Or here's better yet. You thought the unpaid rent was $1,000, but you forgot $10 that he paid you a while ago, or your math is wrong, he actually owed you only $999. If your 3-day notice is overstated by 1 penny, you lose, right? So these things pop up. Now the attorney might come in on the other side, right, and they look at the tenant's paperwork and they say, you know what, the landlord screwed up. I see all my client's payments and he forgot 1 check. His 3-day notice is overstated. All of a sudden I get a bunch of motions and I get a bunch of discovery. I need to respond to those motions. I need to respond to those discovery. You're spending thousands of dollars. And then when I see that, I was like, why is the attorney working so hard? Because the attorney knows he has a winning case, right? And I don't know it yet. So as soon as I get all this stuff, I talk to my client, I'm like, hey, is there something going on? Is there something, I'm missing something. And I try to find out what's going on. Because eventually we're gonna get an offer, look, we want to settle for $10K. And then my client said, well, wait a minute, they owe me $5K in rent. And I'm like, well, we're in the middle of this. And let's say I finally get information of your property manager took an extra $50. We're gonna lose the case. So at this point, if we keep fighting, you're gonna keep paying me, and at the end of it, you're gonna pay their attorney's fees as well. Or hey, this is a very tight case. There's habitability issues with the place. The landlord maybe didn't get to fixing that toilet in a timely manner. The heater hasn't been working for a couple months. I don't know if I'm gonna win. If the judge views that there's a habitability issues and reduces the rents accordingly, and the tenant pays the rent, the tenant is the winning party and they're entitled to attorney's fees. So then we have a discussion. Landlord, I don't know if we're gonna win under these facts. If we keep fighting, there's a strong chance you're gonna lose or the judge is gonna be on their side because of these habitability issues. They wanna settle for 5K. Now, it's gonna take at least 5K for me to answer all these motions and go to the trial, right? Well, but they owe me a bunch of money. What do you wanna do? Do you wanna roll the dice, pay me the 5K, and then they're gonna inflate their bill massively, you're gonna end up paying them 10, 15K, right? Let's assume you don't have an attorney's fees clause, okay? The reason why the tenant landlord came into the case was because he saw the attorney's fees clause. And he saw, you know what, I have a winning case, a potentially winning case, or something in the middle where I can squeeze the landlord. The tenant attorney would have never came into the case if there was no attorney's fees clause, right? Because if he saw the lease and said there's no attorney's fees clause, what he's gonna do? He's gonna say, hey tenant, I need you to pay my fee, right? Well, what's your fee? Well, I charge $1,500. Well, I don't have $1,500. The attorney never comes in. Those motions never get filed. The discovery never gets served to us. Does that make sense? Because he has to get the money from the tenant. But let's say the tenant says, okay, I can muster up $1,500, here it is. And the attorney says, well, let's file motions. Well, how much is the motion gonna cost? Well, it's gonna cost you another $1,500. Well, I don't wanna pay you $1,500. You're never gonna get it back because there's no attorney's fees cost, so the motion is never filed. Fair enough? So in a lot of these cases where there's an uncapped attorney's fees, we're not arguing the facts of the case anymore. We're arguing the probability of whether or not you're gonna win and whether or not you wanna take the risk that you're gonna pay the other side's attorney's fees. See what I mean? So if you're gonna have an attorney's fees clause, either take it out or have it capped on $500. That won't draw in attorney's tenant to come in.